So, Renato, is Trump's Justice Department really going to get away with going after his enemies and letting his friends off the hook?
It's complicated. I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And I'm Asha Renato. I teach national security law at Yale University. I'm a former FBI special agent, and I'm the author of the Freedom Academy Substack.
And we're here to help you understand topics that can't be boiled down into a soundbite or a skeet. Wow, Asha, we are always changing our plans on a minute-by-minute basis, but literally less than a half an hour before we were set to record this episode, news broke that James Comey, former FBI director, is about to be indicted. Unbelievable news.
Yes. So we are recording at 3:47 p.m. on Wednesday, and Ken Dilanian from MSNBC just posted on X about 30 minutes ago that Comey is expected to be indicted in the coming days in the Eastern District of Virginia, where a prosecutor who opposed bringing the case was recently fired, and that at least one element of the indictment, according to sources, will accuse him of lying to Congress during his testimony on September 30th, 2020, about whether he authorized a leak of information. So by the time people listen to this may have unfolded beyond that, but that's where we are picking up right now.
Right. So just a few things to point out. One other thing that Ken Dilanian mentions is that the 5-year statute of limitations on that charge would lapse on Tuesday. Okay, so because that was September 30th, 2020, you'd only have 5 years from that date. And I think it points out something interesting about this entire prosecution. Really, what he's being prosecuted for, according to Ken, is lying to Congress about whether he authorized the leak of information. That authorization presumably happened years earlier. Could have been in 2017, for example, like during the Mueller investigation, because that was where a lot of the questioning from the House Republicans at that time was centered on. And this is a way really for them to bring in the statute of bring this within the statute of limitations. It's a reach to try to get this done within the statute of limitations. It also hooks into a story that we had been following, Asha, and in many ways we were planning to talk about without this context, which was Trump's campaign to pressure and ultimately to fire the United States Attorney for the Eastern District of Virginia.
That's right. So he had pressured the former U.S. Attorney for the Eastern District of Virginia, Eric Siebert, to bring charges not only against Comey, but also against Adam Schiff and Letitia James. And he failed to do that because he was getting pressure to charge both of them with mortgage fraud. And Trump was getting impatient because it sounded like Siebert didn't feel like there was enough evidence to do that. Siebert resigned, though I think Trump, as usual, is claiming credit for firing him, and instead has placed Lindsay Halligan, who is his former assistant and personal attorney who has handled insurance claims, as the U.S. Attorney for the Eastern District of Florida.
Eastern District of Virginia.
Yes. Eastern District of Virginia. I'm sorry. My bad.
And I think that's where FBI headquarters is located. Interestingly, though, of course, I strongly suspect that unless the testimony was occurring via Zoom, which I guess is possible, I have not looked back at that testimony, the actual false statement itself was made in the District of Columbia. It's interesting that the indictment would not be occurring there, given that Congress, of course, is located in the District of Columbia.
Does this relate to what you just said, that they are trying to cover the conduct of actually authorizing the leak which they would argue happened at FBI headquarters.
Yeah, it's interesting from a venue perspective. So there's so many questions and so many issues here. I have to say, obviously we could spend the whole time talking about, isn't this insane that the former FBI director is being indicted by Trump after being the person who was fired by Trump for failing to let Flynn go, right? Trump's close ally and former appointee. But regarding the venue issue, the Constitution requires that criminal charges are brought in the place in which the conduct occurred. So you can't, Trump can't just indict everyone in Wyoming because he thinks that that's a fantastic place for him and he likes the juries there or something like that. If you commit a crime in, for example, Connecticut, where you're located, you have to be prosecuted in the District of Connecticut. And so here, if he actually appeared physically, and that's, I think, an open question. I don't know because I haven't reviewed the video. But if he appeared physically in Congress and a false statement was made in the District of Columbia, then I would expect that the actual crime of making a false statement to Congress occurred in the District of Columbia. And this is an attempt to avoid a jury in the
Well, this was during COVID, though. So it might have been during Zoom.
That's why I said I'm not sure. If it was Zoom,
it was in September of 2020, so there is a good chance that this took place remotely. And I assume that if there were some kind of choice, the calculus that's being made is that the Eastern District of Virginia would be less favorable. I mean, I would think that they're all kind of liberal leaning. I mean, is the DC... Would that be that much more? I mean, I guess from what we've seen lately with all the military there and they're returning no bills, maybe that's it's more defendant friendly than usual, perhaps.
Yeah, not only that. I mean, I think Trump he won less than 10% in DC. I don't remember the exact percentage. It may have been 8%, but it's a very resounding defeat for Trump in DC. I'm sure it was closer than that in the Eastern District of Virginia. As I said, he can't decide to indict in Wyoming or Mississippi or someplace like that. But putting aside all these technicalities, I'm raising these sort of technical issues because they're really important. And it kind of leads me to, I'm going to make a kind of big, bold statement, it harkens back to something that I said before Trump was sworn in. I think this is a very difficult battlefield for Trump to be fighting on. Trump wants to get Comey, and yes, he's going to harass Comey, and he's going to, put Comey through the paces, and it's going to be a very difficult and harrowing experience. But our criminal justice system has a lot of procedural protections, very thick, very robust procedural protections for defendants. And Comey's going to have a lot of ammunition to use to defend himself here. And in many ways, one thing that everybody listening to this and viewing this can have some comfort in is that James Comey, who I'm sure is going to have excellent lawyers. I mean, he at one point was represented by my former boss, Pat Fitzgerald. He is going to be attacking everything from venue to some of the actual factual issues here, because I think seems like an extremely difficult crime to prosecute.
So we think that this crime will be a 1001 charge, which is making false statements.
It's not making false statements, but actually knowingly and willfully making false statements.
Well, I was going to get there before you interrupted. Yes, so making false statements, but then they also have to show that it was done knowingly and willfully, but also that the omission or the lie was material, right? To whatever, I guess, the proceedings that they were having at that time. So it's so hard because I feel like everything blends together. And I had to remember what was happening in September 2020. And this was the weaponization committee that was rehashing. I mean, basically, I think this is all a part of Trump's vendetta to, cast doubt on the Russia investigation and to basically punish all the people who did this. Like, this all goes back to season 1, right? And and this has been an ongoing effort. I think that it's just important to remember that we had the Russia investigation. He fired Comey. A special counsel was appointed. That was Mueller. Just because we might have some younger people for whom this was like 10 years ago, they might not know. That investigation went on. Those findings came out. Bill Barr spun that, and I would say lied about it. Then there was a second special counsel appointed in order to investigate the investigators, the John Durham investigation, which indicted 2 people, and neither of them were convicted. And then we had the weaponization committee, which was there to once again rehash this whole thing and try to cast doubt on what the basis was for this investigation. So I think that part of this, because the underlying allegation based on the reports is that he lied to Congress that he authorized a leak. That's one of the things. But there's New York Times reporting that says it's also that he potentially lied to Congress by stating that he had not seen evidence that, I guess, exonerated Trump and pinned the blame on Hillary Clinton. Like it's just the same narrative that they keep wanting to. They want to make fetch happen. They keep trying to make fetch happen, and this is the newest way to make fetch happen.
Right. So, and there's certain things about this that are going to be, guaranteed gains for the Trump camp, right? In other words, they're going to be able to say that James Comey's been indicted for felonies. They can say that, and that is accurate, right? They can impose a lot of heartache on the Comey and his family, for sure. Expense, for sure. They can put stress on him, for sure. But, you hearken back to those special counsel prosecutions, and that's a great point. And great of what I'm saying here is ultimately the special counsel investigations, the prosecutions were not successful. And I think here, proving that Comey saw or didn't see something many years ago, and then that he remembered it or didn't remember that when in the specific moment in which he was sitting there in Congress, and proving that beyond a reasonable doubt is very, very hard. And I will say that as somebody who's been on both sides of that, both sides of the V, I've prosecuted those cases, I've defended those cases, proving what's in someone's mind without contemporaneous evidence. Like, in other words, Comey texting people right afterwards, like, haha, I got one over on Congress. Something that smoking gun-ish, unless you have something like that, it's just very, very challenging to prove these cases.
Yeah, and I think that, look, a lot of people on both sides of the aisle are not big fans of James Comey. Like he has not made friends in our politics. I think, given how everything has unfolded from Republicans and Democrats. But I think I think this is sort of like the John Bolton thing, right? Like I think you put politics aside when people are being targeted because of personal vendettas. And you mentioned that Comey's going to have the opportunity to challenge this on various grounds, including venue. But I think he probably also has a pretty strong grounds for alleging both selective prosecution and vindictive prosecution, which are 2 different things. Very high bars, but the fact that that Trump was tweeting out that he basically got rid of this other U.S. attorney because he was not willing to move forward on these indictments, that he has hired this very specific U.S. attorney in order to do that, and that, it's harming his reputation. It's, in other words, there's all these personal reasons. And he put this out literally in a tweet. And I assume that is going to make a pretty strong case for Comey to allege selective and vindictive prosecution. We should probably unpack what those entail. But all of that, I guess, would have to happen after he's indicted. In other words, all of these challenges happen only after a grand jury returns, a true bill.
Yeah, I have to say it is very challenging to make those claims, like you said. I mean, I think it would be more vindictive prosecution because selective prosecution is usually like an impermissible classification, like race or
Like a
something like that.
discriminatory. Like you take that
Discriminatory.
you have to show that there are similarly situated people who aren't being prosecuted, and that your motive in choosing to prosecute that person is based on a discriminatory motive.
Right. I mean, I think it's more of a vindictive prosecution would be the argument. Now, as you said the term high bar, I don't even think that high bar is strong enough of a word to encapsulate how high that bar is. It's so high that you couldn't see the bar from the ground. Usually, it's just incredibly difficult to meet. Here, it may be like the one case that proves the rule because it's so obviously vindictive by Trump in so many different ways. But it's the sort of motion that's going to get made and going to get litigated because even if you lose, it's a story that Comey's going to want to tell, and he's going to want to tell it early and often to this judge. And then he's going to, because you're going to also, the judge is the ref during the trial. So you're going to want the judge to recognize this for what it is. And then you're going to find ways to tell the jury that story during trial if you ever get there, which you may never get there. Okay. But in this case, but even if you do, you're going to want the jury to understand the obvious, which is that there's just a ton of bias here and the reason that the prosecution brought this. I will say, when we get to questions of vindictive prosecution, it really is a reminder. You mentioned, Asha, that no one likes James Comey, or he's unpopular. I'm saying no one likes. I'm sure he's beloved by his family, but he's unpopular. He's unpopular on both sides of the aisle. And I think one of the many reasons that he's unpopular amongst Trump's critics is that he exercised very poor judgment in a number of respects when he was FBI director. And many believe, whether you never know one way or the other, many believe that contributed to Trump's election as president. And there's one thing that's interesting here, and I think it's a broader theme that runs through a lot of what's been happening over the last week related to the Justice Department, is that prosecutors have so much discretion and so much power that a lot of it comes down to judgment, right? And here, this is obviously horrible judgment, and it very well may be vindictive prosecution. But there's a certain irony given that Comey got here in many ways, and perhaps Trump got here due to poor judgment or prosecutorial judgment.
Yeah, but I think it's different kinds of poor judgment. So vindictive prosecution, I mean, the standard is that you have to show that you're being prosecuted in retaliation for exercising your rights, right?
Yep.
Like, so you have to show that you're just kind of living your life and doing, what you are allowed to do, and that you are, it's sort of, there's a retaliatory purpose to this. Look, Comey definitely exercised poor judgment. I would not say that he was out targeting people. I mean, I think we can disagree, and he'll go to his grave defending that, he did the right thing. And I think he could have done a lot better, but I also think in his heart of hearts, he thought he was doing something by the book.
I think he thought he was doing something. I think he thought he was doing the right thing, quote unquote.
Yeah.
I don't think he was doing anything.
But he thought he was justified in not doing it by the book because it was the right thing. My point is, well, let's not litigate that right now. My point is, that's a very different category of poor judgment. Then this isn't poor judgment. This is a lack of judgment. Because it is not actually based on any kind of judgment at all. It's not based on any kind of evaluation of evidence or, should I do this or should I do that? It's essentially based on an order by the president of the United States to target one of his enemies. So I
don't disagree with that.
I think that I would not equate these two things.
I'm not trying to equate them. And I want to make that clear. No, I'm not trying to equate them. But I guess what I'm trying to say is this, because they're obviously not equivalent. And it's sort of apparent, I think, that they're not equivalent to me. But I could get taken out of context, so I'm glad that we're clearing that up. It's absolutely not equivalent in any way. But the point that I'm making is that one of the things actually that even makes this prosecution possible, Asha, is that prosecutors have such broad discretion and the bars for actually bringing the cases are low enough that they can get away with doing this. Like, that was our opening question here, right? Can the Trump administration get away with doing this? The only reason they're even in a ballpark, I'm not saying that they're going to get away with doing it. I actually think that in court, this is going to fall apart. And I made that, I thought, a fairly bold argument in the beginning. But I think the reason they're even able to get there is because prosecutorial discretion, and so much is left in the hands of prosecutors that they're able to even get this off the ground, which it should never have gotten even to the starting gate.
Well, I'll push back once again. The reason that there's so much deference given to prosecutorial discretion is because of something called the presumption of regularity. That courts assume that the executive branch is basically following normal processes in arriving at its conclusions in terms of what it's doing. Okay, so they're loath to second guess something based on, because here the Justice Department is going to have all the information. It also has a Justice Department manual. It has the Attorney General guidelines. So in other words, they're not going to start from a bad faith assumption. There's a lot of evidence now across different kinds of cases that have come up in civil cases, the John Bolton case, that the presumption of regularity should not be afforded to this administration. That, in other words, there should be a closer look taken because of, again, the Justice Department has eroded its credibility by failing to comply with court orders, by misrepresenting and evading questions in court or responses, all of these things. Actually, Just Security, we can put this in the show notes. Ryan Goodman and some partners at Just Security have laid out this amazing document which show different cases. Again, this is not all one judge, different cases that have all called into question the integrity and veracity of the Department of Justice. So I would argue that, yes, in ordinary circumstances, it's a very, very high bar. And there's a lot of latitude that's given to the Justice Department. But I think that latitude has narrowed. And I think that there is a reasonable grounds here to not give the Justice Department the presumption of regularity that is normally given. Basically, it's squandered that capital.
So, I think I look at it from a slightly different perspective. I think that our system is built on, in many ways, in criminal, and when I say our system, that's such a broad thing. The federal criminal justice system, and really to a lesser extent, the state criminal justice systems, but the federal criminal justice system is built on a wide array of deference that's given to federal prosecutors, and what that can be abused and is abused at times by prosecutors. But there exists various norms, various guidance, and so forth, some of which you cited, like the Justice Manual, that reduces that abuse. And cultures within U.S. Attorney's Office and the Justice Department also reduce that abuse. But it's a thin reed. If we should have learned anything from Trump 1, the first Trump administration, is that norms and culture and tradition is not enough to protect us from a runaway government and a bad faith government and an authoritarian seeking president. And this, to me, punctuates the failure from the Biden administration to look at the abuses of the Justice Department in the first term and turn them into something more robust than some vague speeches and a return to norms and values that were, from the past, because those norms and those values don't protect James Comey and his family right now.
Well, the norms and values don't protect him because the people who are still inclined to follow those norms and values are being fired. Okay, so we're starting with Danielle Sassoon. In other words, I think that culture, the people who have been in the Justice Department still have it. Even some of these conservative Justice Department lawyers, Eric Sieber was put in place by Trump. He's not some Biden holdover. Like, this guy is a career prosecutor who was literally put in place by Trump, who looked at all of this evidence, and he is actually still socialized under those norms and values and said, look, I can't bring this case. And he resigned / was fired. And there is now an insurance claims attorney that is now running that department. So I would argue that the norms and values are actually being transformed, okay, so that they're not controlling. That doesn't change your point. The point is that they're not enough now. But I just want to say that, like, it would be not giving credit to the people like Danielle Sassoon, like, Eric Sieber, like people who I think are trying to stand up to this. But, the Supreme Court has basically given the executive branch carte blanche to just fire everybody without cause, which only makes it easier for those internal guardrails to just not matter anymore.
Yeah, I hear everything you're saying. I mean, look, I think I was an ethical prosecutor, and I went out of my way and really searched my soul on a regular basis to make sure that I thought I was doing the right thing in the cases that I had. And part of that was a culture that we had and norms that we had and guidance, like the Justice Manual, then called the U.S. Attorney's Manual at the time, and so on. I do think, I mean, in many ways, there's a part of me that's a product of that system. But there's a reason, that you having governmental processes that rely on having good people there is dangerous. It's why we don't want to have a monarchy. It's why we have all these checks and balances built into our system. And thank goodness we do have checks and balances to a certain degree built into the due process protections for criminal defendants, because we're going to need every one of them in this case to defeat this. But I don't think it's enough. And I think we need to learn and take, and to me, it's a very bold thing to say. I think we need to really re-examine, protections for criminal defendants in an age where you have vindictive prosecution not only taking place, but celebrated.
So speaking of protecting defendants and, we don't want people without ethics in these government positions. Renato, did you ever accept bags of cash when you were a prosecutor?
No, I did not. I did prosecute people who accepted bags of cash in parking lots and so forth. That did occur. But I was never on the other side of that, never the receiver, only the prosecutor on those cases.
So we have this interesting juxtaposition against the looming Comey indictment, which is that Tom Homan, who is the White House border czar, is apparently on tape for taking $50,000 in cash from FBI agents in an undercover operation from September of 2024. However, that case, this kind of gets to your prosecutorial discretion, right? That case was quietly closed early this year by one Emile Beauvais, then Deputy Attorney General of the Justice Department, before he got elevated to being a Third Circuit judge. So, and basically at this point, the administration is just saying, move along, nothing to see here. Tom Homan has been on TV. He hasn't denied taking that cash. And it seems like what happened was that he was taped taking this cash. Allegedly, he said that in exchange for the cash, once he got a position in the Trump administration, he would then be able to offer access. Like, he would be able to use his position to give people advantageous access to the president. And I'm assuming that the investigators wanted to wait and see whether he gave the quo to the quid, to establish the quid pro quo. And that's why he wasn't charged at the time that he actually took the cash. Like, in other words, they needed to close the loop, as it were. But before they could do that, this case was closed.
So, it's interesting. This I do think I agree with you 100% in terms of prosecutorial discretion, and it really kind of gets to the same point from a different angle. So I did note the same thing you did, that he appeared on television. I think it was Laura Ingraham, very friendly
Oh, yeah.
audience from Fox News. She asked him whether he accepted the 50K in cash, and he just said, "I didn't do anything illegal. I didn't break the law," something along those lines. Didn't commit a crime, which doesn't answer the question. The question is, did you take 50K in cash in the plastic bag or whatever? But I will say that part of what happened there, I suspect, Asha, is there's been a long line of jurisprudence in these bribery cases that have very much narrowed the government's ability
Yeah.
to prosecution's ability to bring those cases, and
Thanks to the Supreme Court.
yeah, and that's really a Supreme Court. This is pre-Trump Supreme Court. The trend started. It's
Yeah.
just the conservative Federalist Society kind of strain in the Supreme Court that really led the court to very much narrow those. Obviously there's the bridge cases that Trump now likes to cite because he doesn't like Chris Christie anymore. But there was a number of cases along those lines. The bottom line, though, is that what I suspect may have happened here, and of course we don't know the specifics, um, what we know is that this cash was, like you said, received, but at the time he held no official position. He didn't have the ability to trade, because what bribery is trading something official decision or act, in exchange for something of value. So obviously 50K in cash is something of value, but what was he trading? Trading future goodwill, gratitude. What was he trading, right? And so they probably had some proof issues there that they were trying to work on. And like you said, the case got closed. But we don't know the details. Why? Because prosecutors do this stuff in secret and they make decisions. And if whether, if they make a corrupt decision, you may not find out about it. If they make a decision in which, by the way, someone's exonerated, you don't always hear about that either at the end of the case. So I do think it's something that the minority and Senate Democrats and House Democrats are interested in, but they don't have the ability to subpoena. They're sending letters and want to look into it, but it's something that deserves very serious oversight.
And I think this is a really important piece to highlight about the abuse of executive power, because we often focus on the abuse of office in terms of commissions of acts, right? Like going and doing things, going after enemies. But there is also an abuse of power in omissions, when power is not used to do something. So in this case, to not prosecute someone who or continue to investigate someone who may have committed a crime. The Eric Adams piece, to basically withdraw from that. I mean, at a broader level, an omission might be if one of our NATO allies is attacked and Trump if he doesn't send troops there, right? The thing is that there's no mechanism to make the executive branch perform a duty. In some ways, there's almost more constraints to check or have oversight over overreach, but there's almost nothing that can compel the executive branch to act. And it's just something to think about, because, corruption goes in both directions, I think. And here what we have is the weaponization. I mean, to get to our original question that we talked about, weaponization is both using the levers of power and the law to go after people you don't like, but then also using it to shield people that you do like. And this kind of undermines the entire ethos of the Justice Department, which is to prosecute people without fear or favor, right? Like, that's the whole point.
Yeah. It's really interesting, right? And, you talked earlier about going back to season one. One of the themes of season one, so to speak, early Trump one, is there's that H. and Robin phrase, who watches the watchers, right? In other words, if you are the one in the executive branch and you're supposed to be the one faithfully executing the laws, who ensures that you're doing that? And it generated a lot of debate at the time because we had special counsel regulations. But of course, the special counsel, is part of the executive branch. And Trump famously or infamously tried to fire the special counsel on multiple occasions, right? And of course, fired the FBI director that we were talking about earlier today. And so how do you have the power to investigate and take action if there's crimes that are being committed from the Oval Office? And I think the answer that the United States Supreme Court has given us is no one watches the watcher. He has unlimited authority and unfettered ability to engage in criminal activity while he's in office.
Impeachment seems like the only alternative. That's what they would say.
Right. And impeachment in a world in which it's almost impossible to get, a few people to switch party lines. Very difficult, right? You get 2/3 of senators agree on anything. Maybe renaming a post office. They might be willing to agree on that.
So the other big news this week, Renato, is that Trump issued a proclamation in which he put restrictions on the entry of certain non-immigrant workers, specifically people applying for an H-1B visa. And in particular, he put a $100,000 price tag on that, which caused a lot of confusion and panic, once again, reminiscent of season 1 to the Muslim travel ban. For those that remember that was complete chaos across airports all over the country. And basically you had the same thing unfolding again this time, which, there were people literally on flights and companies that were frantically trying to get their employees to get back to the country before this went into effect, because the language of this proclamation was not clear on to whom it applied.
And even to how much the money was. In other words, there's a $100,000 fee, by the way. It wasn't even clear whether that was for people who already had H-1B visas or new people. It also wasn't clear whether it was a one-time charge or not. It turned out, I think, to be a one-time charge. But I think, it's annual? I thought it was one time.
It's annual. I'll tell you more about it.
You know what? There you go. Confusion confirmed. Because I thought I had read it was the other. But I think we should explain to people, Asha, a little bit about what H-1B visas are.
Yeah.
A very limited pool. I think it's 50,000 immigrant is the cap that are allowed.
With each 85,000, but there's a cap.
There's a cap. A relatively small number of people are allowed in these visas into the country every year. Yeah. And they're typically people who are very high value. They're sponsored by companies who come in and they actually provide a tremendous amount of value to our economy.
So the requirements are that they are foreign professionals with a college degree and they have a valid job offer. So typically this is high-skilled labor. A lot of, computer engineers and things like that from India. So this would largely impact industries like the tech industry, for example. And Congress has imposed allowed a fee of anywhere from $5,000 to $10,000, which are intended to recoup the executive branch's costs of, doing the administrative work of issuing the visa. As you mentioned, there's a cap. I saw the cap as 85,000. But because there's many more professionals who apply for this or want this visa than are available, it's issued by lottery. And so people enter a lottery to do it. Now, what Trump has done, of course, is he has increased the cost from that 5,000 to 10,000 that I mentioned to 100,000 annually. That's again, this is my research that is has found this, which would be paid by the company. And so you can imagine that this would become incredibly costly. And the proclamation claims that the reason that he's doing this is because this is taking jobs away from Americans. Because what companies will do, he's alleging that companies are getting this high-skilled labor from abroad, paying them lower wages, which is resulting in Americans not being able to get jobs. We can talk about whether is an accurate description. Importantly, the proclamation gives the Secretary of Homeland Security the latitude to waive the fee if the person applying for the visa, if their entry is quote in the national interest and does not pose a threat to the security or welfare of the United States, end quote. So I think that that's an important thing to highlight because it is a common theme that we're seeing in these various ways in which these different things have been targeted, whether it's universities, whether it's law firms, whether, is an giving the executive branch the flexibility to basically excuse, or tariffs, to excuse certain people or exempt certain entities from it, which of course puts an enormous amount of power into the hands of the executive branch and opens the door to, frankly, a lot of corruption, right? Because if you're essentially on a pay-to-pay kind of scheme, then, as we've kind of seen in the tariff context, that is opening the doors for, people to pay to play, basically.
So one thing that, I want to underscore for people is that, obviously, while these aren't asylum seekers, some of the others that we've talked about who obviously are desperate to enter the United States, people who are coming here on H-1B visas, this is literally the course of their life that is being altered here. Like, these are human beings' lives and their ability to build a new life in the United States. And these companies, of course, they're making planning and so forth based on these people being available and to work for them. But secondly, I just think it's very much in a way playing politics with people's lives, which of course is sort of common. We could repeat that every week on this podcast. But I think secondly, one thing, just even if you're a conservative, even if you're somebody who's a MAGA loyalist, and let's say you're very concerned about immigration, this is really the United States creaming some of the most educated and competent people from other countries and bringing them into the United States. Like, these are people who countries want to have there because they're generating so much extra value for, like you said, tech companies and so forth. So it's an odd move that, in many ways by the Trump administration, which at times, of course, has been courted by tech companies.
Yeah, and importantly, it's also a market that we cannot supply in the United States. And so this idea that it's actually displacing, American workers is not, I think, true, right? And I'll talk about some of the ways in which the law actually addresses that as it stands. But just to kind of give some legal background on this, so I mentioned the travel ban, and basically the provisions of the Immigration and Nationality Act that Trump is relying on for this proclamation is the same one that he used for the travel ban. So this is a provision that gives the president the authority to restrict the entry of a class of people. I'm reading from the statute. Whenever the president finds that the entry of any aliens or of any class of aliens into the United States would be detrimental to the interests of the United States, he may, by proclamation and for such period as he shall deem necessary, suspend the entry. And of course, he did this with the travel ban, with people from certain countries, and that was upheld by the Supreme Court. And it's interesting because in that case, part of how they upheld it is, they said that the travel ban was based on the security threats that were ostensibly created by people from certain countries coming in because they didn't have proper vetting procedures. And they said this falls into the sphere of national security and foreign affairs, against those buzzwords that, the executive branch loves, that are in the special competence of the executive branch. In other words, it made sense for Congress to delegate that because the executive branch would have the information on, what the current threat scenario is, et cetera, et cetera. I mean, we can disagree on whether the ban was appropriate. And it definitely does get to the fact that Congress has delegated a lot of authority to the president. But I do think that there are very important differences between that ban and this one. And there was a very similar restriction that Trump tried to pass in the late stages of his first term, that the defendants were able to, or sorry, the plaintiffs were able to get an injunction against. And we can kind of unpack what that court said, because I think it might have some bearing on what happens here.
Yeah, that's interesting. I guess I've always thought that where this ends up is this was a mistake that's going to get corrected. I mean, I was just looking online to see, I mean, the Commerce Secretary claims that this will now be a one-time thing. Maybe they'll waive it, until people forget about it. It's hard for me to believe that this is going to remain in place given the amount of confusion it is causing.
I think part of what the problem here is that you have competing agendas within the Trump administration, right? So, you have the tech bros and oligarchs. For those who follow my Substack, I have a whole MAGA map that kind of lays out the different factions, but the tech bros and oligarchs want and need people on H-1B visas. Again, this is highly skilled labor. They need them here. But you have the white Christian nationalists and the, right-wing extremists who really want to just reduce the number of immigrants in this country. They want to make the country more white. And I think this is where the Stephen Miller agenda comes in. So these are clashing. And we saw very early on, there was a clash between Elon Musk and I think Stephen Bannon about the necessity of H-1B visas. But more importantly, I think this is a separation of powers issue. Because once again, Article 1 gives Congress the power to make rules for immigration. And under that authority, they passed the Immigration and Nationality Act. And as I mentioned, in 2020, Trump tried to actually restrict entire classes of visas from entering the country. So not just H-1B, but H-2B, L visas, J visas. I don't remember exactly what L is, but J visas are like, I know this because au pairs come in on a J visa. They're like sort of like student exchange, but they're not actually full-time students. And I knew a lot of people with au pairs were like freaking out. And what the court said when these plaintiffs went to get an injunction, and these were tech companies, these were people affected, same people that are affected in this, but also a broader class, is that the delegation of authority to the president, while there might be a lot of latitude when it comes to national security and foreign affairs, like in the travel ban, that doesn't extend to the president essentially making domestic economic policy. Because it was sort of under the same rationale that, this is taking away jobs from people in the United States. So they made this domestic foreign distinction. And they basically said that, unlike the travel ban in 2017, where the executive branch was filling in gaps that Congress couldn't do in terms of like who might be dangerous in entering the country, that allowing the president to just wholesale restrict entire, classes of visas that Congress has created essentially is making Congress superfluous. It's eviscerating its power to determine immigration rules and just allowing the president to legislate on it. And I think the same thing largely applies here. This is a more narrow proclamation than the one that he did in 2020, but it is applying to domestic policy. There's no evaluation or findings that, this is taking jobs away. And in fact, what the court said in 2020 was that Trump's proclamation in that case, quote, completely disregards economic reality and the pre-existing statutory framework. So it'll be interesting. That injunction was issued. That was in October of 2020. And then, of course, we had the election. Presumably, Biden rescinded that order. So I guess it never got litigated all the way to the Supreme Court or something. But I think this is much more like that than the travel ban. I want to call it the Muslim ban, which is because that's what it sort of was. But the travel ban early in the Trump first administration that the Supreme Court upheld. This is different.
Yeah, to me, it fits in within a larger trend of Trump trying to accomplish on his own things that he can't, right? I mean, we have this, I feel like we spent so much time over the last months talking about Trump trying to issue executive orders to essentially write legislation, right? Or do other things that he has absolutely no authority to do on his own. And this, I think, is just another example of him trying to rewrite U.S. immigration policy. I mean, H-1B visas are provided for by law, and there's statutory fees and so forth. And he's only gotten one bill passed through Congress that I can think of, maybe two, his entire presidency thus far. I mean, that, his first year thus far has been a lot of proclamations, a lot of statements, and not a lot of actual, where's the beef, like in terms of actually getting things through Congress. And it's because he either can't do it or just doesn't care and doesn't respect.
No, it's a strategy, Renato. So Project 2025 has as one of its explicit goals to basically usurp Congress's authority. So this is what our colleague, Professor Kim Lane Chappelli from Princeton, she says that this is echoing Viktor Orban's tactics. And what she calls it is a counter-constitution. In other words, you can't amend the Constitution to basically make the president a dictator. So what you do is you issue all these executive orders that more or less rewrites the Constitution the way that you would want it to look like. Then you let it go up to the Supreme Court and see which ones stick. Okay? And what we've seen so far is that, at least in terms of allowing the president, as we've talked about in previous episodes, to continue doing the usurpation, even on an interim basis, this court seems pretty on board with that. So I think there's a strategy here. I don't think that it's just that he can't get it done. I think that this is really a way to enshrine as a matter of constitutional law that he can do it.
Well, if that's the case, this is going to be even more difficult of 4 years than I feared, right? And we should be really concerned about this, even if you're somebody who's not focused on H-1B visas.
100%.
So, Asha, before we go, we recently had our happy hour for our cruise, and a lot of the people who've signed up, which was a lot of fun.
That was a lot of fun. I get more excited every time I hear about it. It just sounds like, laid back. I having been only on 2 other cruises that I think were much, much bigger and different. One of them was a Disney cruise, and one was like a Carnival cruise from like a long, long time ago, which I'm never going to go on another Carnival cruise again. Not least, I mean, it was crazy, and also because we went to a stand-up comic, and he insulted my mom.
Oh boy! Wow.
This was in the late 90s, so I guess you are allowed to do that. But like, he insulted her for being Indian. He like made fun of her bindi.
Oh wow!
It was gross. I'm just putting this out there. I hope somebody from Carnival is listening to this, because I will never ride Carnival again.
Wow.
Anyway, but this is our cruise. It's going to be much classier than that.
Yes. No, Oceania is a more of an upscale experience. My wife and I had gone on an Oceania cruise a couple of years ago and really enjoyed it. Or actually, was it last year, and really enjoyed it. And I think it's going to be a lot of fun. We'll be going to Alaska. And one of the cool things somebody on the Zoom mentioned was the Fat Bear contest, where there's like the whole, like, everyone gets to wager on like which the fattest bear is going to be during that, season where they fatten themselves up before hibernation. So my wife and I were looking at all the different photos of bears last night and trying to pick. We did not bet. But I think Chunk looks awfully chunky. Let's put it that way. That is, my money is on Chunk. My virtual money is on Chunk.
Okay, I'm going to check out the Fat Bears. I'm interested in the 1 mile zip line that goes 50 miles an hour.
Yeah, I'll be enjoying you on the zip line. I'm not doing that myself. That's insane.
You think that's insane? You're strapped in.
Okay.
60 miles an hour seems really fast, though.
Yeah, no kidding. That's
for like
not for me.
for like a mile. I guess that's only a minute though. If you're going 60 miles an hour.
I'm gonna watch the bears eat salmon, and then I'll wave to you while you're in the zip line. You're not gonna see me because you're gonna be going at 60 miles an hour over me and the bears.
All right. Okay. Well, maybe there'll be somebody else who will join me.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.